Hey everybody, and welcome back to the Tangle podcast and the Tangle YouTube channel. Today, we have a fascinating debate about bail reform and some of the changes that are happening right now in this space. And we've brought on two people who have some pretty strong fundamental disagreements about this issue, as you'll see. One of our guests is Ken Good. Ken is a bail attorney and a board member of the Professional Bondsmen of Texas. He has argued cases involving reforms to the cash bail system before the Supreme Court of Texas and the Texas Court of Criminal Appeals and written extensively on the topic. He received his law degree from Texas Tech School of Law. And we're also being joined by Kiah Duggins. Kiah is an attorney at the Civil Rights Corps and litigates against unconstitutional policing and money bail practices nationwide. Before joining CRC, she worked with the ACLU of Northern California to challenge instances of police misconduct and address other issues in the criminal legal system. She received her law degree from Harvard Law School. Both of these guests have really strong feelings about the issue that we're going to discuss, which you will see in a moment in this interview. I do want to just give a little bit of context here. You're going to hear both Ken and Kiah reference the O'Donnell v. Harris County case a few times. They worked on this case on opposite sides of it. They were both involved in different fashions, but made for a very interesting conversation and one where, they obviously were coming from different sides of it. So they had pretty strong feelings about the case and they reference it a few times. I asked Kiah in the interview to briefly explain it, which she does a much better job than I could. But just because the conversation kind of starts with that right at the top, I want to give a little bit of context that Harris County has a policy and a practice of using secured money bail to impose pretrial detention on misdemeanor defendants who are too poor to pay. What that means is that if you get arrested for a misdemeanor offense, you are brought into your pretrial hearing, you're asked to pay bail. If you can't afford bail, they detain you, they put you in prison. So that process has been challenged and that case went to court. There was a settlement. You'll hear a little bit about that. They both reference it. They reference the constitutional issues at play and why the case, was tried the wrong way or the right way and a lot of the challenges that have been spawned out of it. But it is one of the cases that is, the most consequential to the cash bail reform issue. So I just wanted to give you a heads up. You're both going to hear them talk about it a little bit. We get into some of the nitty gritty legal stuff. And we also talk more broadly about cash bail reform and some of the processes around it. They also both made arguments about the evidence that they have to support their position. So I followed up with each of them to just get some citations, get some studies, anything they wanted to send me to sort of buttress their position. So if you're curious to learn more about that, you can find some of those links that were passed along in the episode description on our YouTube channel or on our podcast. I hope you guys enjoy. It was a really fascinating conversation for me, tense at times. That's natural. I thought Kiah and Ken both did a very good job of addressing each other civilly and, with some grace and some attempted understanding. And maybe we didn't make a ton of, ground on finding some common agreement. But for me, it was a fascinating conversation. And I think for you, it'll help you make a decision about how you feel about this issue. So without further ado, here's the interview. Well, Kiah, Ken, thank you both so much for being here. I really appreciate it. Before we jump in, I think just for our audience, it would be awesome to hear a little bit about how you each came to study and work on the issue of bail reform. Ken, maybe we can start with you. If you could tell us a little bit about your background.
Sure. Well, thank you very much for having me here. I mean, this is an issue that has really taken away a lot of time and where I've really educated myself. But I would say in law school, I excelled in doing national teams. I was on a team that did the best brief in the nation. So I've always had an appellate background type of experience. I was a 4-year attorney when I argued my first case at the Supreme Court of Texas. And so no matter what I've done, I've kind of kept my appellate work going. I've argued the two most important cases in Texas on the bail side of the world and won both of them. And so then I started finding this issue. I was asked to go to a hearing in the O'Donnell case, which is probably one of the first cases, one we may talk about today. And I came out of that hearing going, oh my God, this case is going south, and I don't believe that it's going in the proper direction under the law. And so I said, we are going to have to become experts on these issues. So I became educating myself on these issues from my background as appellate attorney. Started writing articles about these issues, and then we started our own podcast. And so I've had guests from some of the cases that have gone through the system. And so I have diligently worked to try to become a resource for these types of issues when they arise across the country.
Love it. And Kiah, what about you? How did you come to work on bail reform issues?
Yes, hi. Thank you for having me here. So, like you said, my name is Kiah Duggins, and I am originally from Wichita, Kansas, and I went to Wichita Public Schools from kindergarten through college, and then I eventually went to and graduated from Harvard Law School, and now I work at an organization called Civil Rights Corps, where I litigate cases against police abuse and pretrial detention nationwide. And what brought me to this work is very personal. I'm a descendant of enslaved people who have been exploited economically and physically by our criminal legal system for hundreds of years. And to put a finer point on it, on the day that I took the LSAT exam, which is required to get into law school, my uncle was detained pretrial, was killed on the same day that I was there to take my LSAT. So my family has been very personally affected by pretrial detention and by the harms of the criminal legal system. And I went to law school to help remedy some of those harms and make sure that other people don't experience it. And Civil Rights Corps is actually the organization that filed the O'Donnell lawsuit that Ken just mentioned. And the goal of that lawsuit was to make sure that people who are charged with misdemeanors, but who are legally innocent, do not sit in cages pretrial simply because they cannot afford bail. And we actually were able to win that case. And studies since the O'Donnell decision came down have shown that crime has actually gone down in Harris County since the O'Donnell decision happened. So that's what brought me here, and I'm really excited to be here today.
Thank you, Kiah. That's a great segue to my first question. I mean, there are so many different angles, I think, and pros and cons about how to address bail reform. You know, what kind of issues you're weighing when you make policies around bail reform. And I'm definitely going to give both of you a chance to share how you frame it in your own minds. But obviously, oftentimes the issue comes back to crime. And Ken, I know that one of your core arguments is that you feel like there's evidence that, you know, a lot of the bail reform policies that we've seen in the United States have led to a rise in crime. So I want to start there. Maybe if you could specify what kinds of crime you're saying have been driven by bail reform, and then maybe what kind of bail reform specifically we're talking about when you make that argument.
Sure. I think I'm going to, I thought about that question recently, and I was thinking, when I started discussing these issues, it was from the O'Donnell case. And I want to express a little bit about that in a minute, but let's focus on the question. And that was all about misdemeanors. So I would say if you looked at the body of stuff that I've written, you would say that Ken would focus on misdemeanors as the source of the problem. But I don't believe that's true. I would say anytime you have reforms that take away accountability for whatever crime, that you are going to have a rise in crime. I did a podcast recently with the sheriff from Coleman County in Alabama, which is the Schultz versus Alabama case. And they had an injunction in place that they lived under for 4 or 5 years until it was reversed. But that was on felonies and misdemeanors. And he said all crime went up across the board until that injunction was lifted, and then they got a handle on it because they reintroduced accountability. And so, and then I would just go back and say, as to Kiah's point about O'Donnell, it looks like we're just going to have a fundamental disagreement on O'Donnell about whether it was won or whether it's even been successful, because I don't know how many times a judge can be reversed in a case. O'Donnell, it wasn't one time, it wasn't two times, it was probably 5 or 6 times. And the Fifth Circuit, in the most recent analysis of O'Donnell, said it should have never been filed in federal court. And so to say that that was a success, and you can't even argue that it's continuing to be a success. I mean, that's at the very least disputed. You've got the monitor saying it's okay. But even after I pointed out some issues on failure to appear rates, they've even backtracked and said you really can't determine the failure to appear rates from O'Donnell. And then you've got the DA issuing a report saying, no, the failure to appear rate's much worse, recidivism's much worse. And then the police officers unions issuing a report saying it's at least 75%. There's a Harris County Court Watch saying it's on average 80% for the last 2 years. And so it looks like we're just going to have a fundamental dispute about whether even O'Donnell is successful, because if we can't acknowledge that there are different conclusions on that, at the very least, it's hard to have that type of discussion because we're just going to get stuck on describing jails as cages. We can't ever have public safety. And that I just fundamentally disagree with that.
Really quick, Kiah, I want to give you a chance to respond to that. But first, maybe if you could just give the outline of the O'Donnell case. I mean, I have some familiarity with it, but I imagine that a lot of our listeners probably don't. So we'll do a little bit of the Star Wars thing here and work backwards and go back to the beginning really quick. I think that would just be helpful for people who are listening.
Yes, of course. So an overview of what the O'Donnell case was about. So this is a case in Harris County, Texas. Harris County is the county that Houston, Texas is located in. And it has, I believe Harris County is the third largest county in the United States, but feel free to correct me if I'm wrong on that. But it's a relatively large county. And what the case was about is that before the case was filed, people who were legally innocent but accused of misdemeanors would receive a money bail amount. And to be clear for all the listeners, what money bail is kind of like a security deposit saying, if you pay this monetary amount, that means you're promising to return to court. So if you do return to court, we will return your deposit of money bail back to you. So that's kind of how money bail operates in a nutshell. And in Harris County, Texas, people who were accused of misdemeanors were given money bail amounts. And if they could not afford that money bail amount, then they were held in a cage pre-trial. Once again, these people are legally innocent. They had not been convicted of a crime yet. And so our case in O'Donnell was basically to say that it's unconstitutional to hold people in jail simply because they cannot afford this relatively arbitrary money amount that has been set in their case, especially when they haven't been convicted of anything. And so the claims that we brought were related to equal protection, procedural due process, and substantive due process. And the case resolved in the plaintiff's favor in that now people cannot be held in jail simply because people who are charged with misdemeanors in Harris County cannot be held in jail simply because they cannot afford a money bail amount. And it's led to the pretrial release of many people. And the study that I was referring to earlier when I said that studies have shown that crime has gone down since the O'Donnell decision is a study done by a peer-reviewed study done by UPenn, the Quattrone Center. It was released August 16th of 2022. So it's relatively recent. And that analysis from that study shows that crime rates have not increased because of the O'Donnell decision. And in fact, crime has gone down.
Kiah, I do want to hear about kind of the interaction of the bail process and crime. But as I understand it, I think one of, your core arguments is also about the constitutionality of, these bail practices. I'm wondering if you could talk a little bit about how you think about that in the first place, whether it's legal or constitutional to ask for people to give their money while they await trial, and if they can't, imprison them.
Sure, I'm happy to talk about that. So the short answer to your question is money bail by itself is not unconstitutional on its face, but there are some ways that money bail is imposed that can make it unconstitutional for certain people. So to be a little bit of an annoying lawyer here, the original purpose of money bail, or of bail in general, was a promise to return to court. So back in the colonial days, that's what bail meant. And money bail is essentially a security deposit saying if you give your money and promise to return to court, when you do return to court, we'll return that money to you. So that's what money bail is. And money bail on its face is not unconstitutional. It's essentially a promise or a security deposit that represents a promise to return to court. The constitutional claims that civil rights court brings in its class action bail cases are claims related to equal protection, substantive due process, and procedural due process. So equal protection comes up because you might have two people who have the same charges and have the same money bail amount, but one person can afford to pay that money bail amount and they get released, and one person cannot pay that money bail amount because they can't afford it and they get detained. And so that creates an equal protection issue for indigent defendants or defendants who don't have a lot of money, because two people who had the same situation got treated differently. Substantive due process is basically the idea that we all have a fundamental right to pretrial liberty. And so I think the best way to describe this is kind of the general idea that we are all innocent until proven guilty, and none of us should receive punishments until we're proven guilty. And when people are receiving a bail amount, they are pre-trial, which means they have not been convicted of any crimes yet. So that's substantive due process. And then procedural due process, finally, I'm wrapping up this lecture that I'm sure some people don't want to hear. But finally, with procedural due process, that's the argument that there has to be procedures in place to ensure that people's constitutional rights are protected. So some of those procedures include having an attorney representing you at your bail hearing, or being able to present evidence about why you are not a flight risk or not a safety risk, and being able to confront the evidence from the government and cross-examine the evidence from the government to say, to challenge it and say that you do not need to be detained pre-trial as a legally innocent person. So those are the three legal claims that we bring against bail systems when they start detaining people simply because they cannot afford their money bail and for no other reason.
Ken, I'm curious to hear, your response to that, but, to put a fine point on it, how you think about the constitutionality or the legality of imposing cash bail on people, separate from, I understand that you think it's a sound policy that's effective at reducing crime. And I do want to talk a little bit more about that, but I'm curious about that core question too, of whether you feel like there's strong constitutional grounds to impose bail and why.
Well, I do agree with what Kiah has said about the three issues that generally are raised in this type of litigation. And I will even point out, I think at the time that the O'Donnell case was first filed, these issues had not been settled. And, there was some question about what the result would be. But I would say on your question, the constitutionality, the Constitution sets the floor. Here's what everybody must have from a constitutional basis. And above that floor, then the states, the communities, they can do what they want. And I think where I come from a different perspective is I think that sometimes Kiah and the Civil Rights Corps is arguing that the floor is much higher than the floor. The arguments that they've been making since O'Donnell have been reversed, I think, essentially at every Court of Appeals now. The 11th Circuit has ruled bail is substantively constitutional. The 5th Circuit has ruled that bail is substantively constitutional. And so the floor is, like she has acknowledged, bail is constitutional. So it can't go away just because it exists. And I think on the procedural due process, I think the great example of what that argument is would be the O'Donnell case itself. O'Donnell used bail schedules. So your bail was set pursuant to a schedule. And where the problem was that a person who was poor had no opportunity to say, hey, I can't afford that. I need to have that amount lowered. And so the problem under the Constitution is there was no procedure in place for them to say, I need a deviation, because the judges would say, you can't talk. Anything you say will be used against you. And so But what we have found out since is once those procedures are put in place, then it goes to a very low standard of review. That's the reason why, even in the O'Donnell case, that Rosenthal got in trouble. She issued a preliminary injunction, it went up on appeal, was reversed. She issued a second one, went up on appeal, and was stayed. The reason why O'Donnell is in place now is because of a settlement, not because of any finding from the Court of Appeals. In fact, the settlement encased procedures that had been reversed by the Fifth Circuit. And so since then, the Daves case has completely reversed O'Donnell and said it should have never been filed. And so I understand that we're arguing about O'Donnell because that's the big claim to fame, but it has no standing in the legal world. It has been completely reversed. The only reason why it's in existence today is because of the politics. The politicians don't have the will to go into the court and say, let's set that aside because the court says you have no jurisdiction and there's no basis. This case should have never even been brought in federal court. Every case since then they have lost, even the Booth case, which just was on the issue of whether they should provide counsel at the bail hearing. That was just dismissed in the last 60 to 90 days, and they didn't even appeal that case.
A quick follow-up to that. I'm just curious. I mean, do you find, at least in your work that you do, or in some of these counties, you talked about like some of the sheriffs and the law enforcement you talk to, that cash bail is an effective way to actually get people to show up for court? I mean, the way Kiah explained it is sort of this like deposit that you put in, you're supposed to get your money back when you show up. The people who can't do that end up going to jail. Obviously, once you're detained, those people are showing up for court. But do we have evidence that, requiring that cash as a means to get people to return is actually necessary, or that most people will come back and show up for their court date, even if there isn't a cash bail requirement?
Yes, I think that there are. But I will, I'll even say that there are some alternatives that get close to the private surety system, but those systems like the DC system are so expensive. I've done a podcast with a former attorney general from DC, and he said if they had to vote on it again today, it would never pass because it's so expensive. But I will say the private surety bail system has the lowest failure to appear rate of any system in place. Anything else is at least double that, or even worse. I mean, I think we would agree that if Harris County, we can disagree with whether it's right or not, but if we should be able to agree that if there's an 80% on average failure to appear rate for all misdemeanors in Harris County over 2 years, that's not good, because criminal cases, you can't get a case resolved if they don't come to court. You have to put the case on hold until they return. So, and also, I think we don't give the private industry credit for the special sauce that they have that makes them so successful. I mean, nobody likes the private industry bail system. If they could get rid of it, it would. It's been around for 200 years for a reason. And it does one thing and does it very well. And it's a personal relationship industry. It gets relationships with defendants. And if defendants can't go to court, and we know it, we go get them because we have an incentive and we take them to court. We do things that the public sector could never do. And then we have this one thing that the public sector doesn't have, and that is when there's a failure to appear, the private industry has an incentive to get that person back and get their case back on track. And they have time limits on that in Texas. And so that gets the case back on point quickly and gets cases resolved more quickly that no other system has. If it's just a simple release, which is what I would call no bail, zero bail, anything or a personal bond, then that's just a warrant that goes down to the warrants department. And usually that means they have to commit another crime. And then the bail industry gets the family involved. And you know what? The family involvement is the biggest impact on getting people to turn around and become productive citizens. By removing the private industry, we're taking away family involvement.
Kiah, I'm curious how you think about that question of the effectiveness of bail in the context of, getting people to appear in court, whether it's a good incentive, whether it's a functional incentive. How would you respond to some of that?
Yeah, so some of the statistics, Ken, that you cited, I would love to see the sources for those, but we can get into that another time. But the short answer to your question is that there are many effective ways to get people to court, such as providing transportation to court or giving court date reminders. And examples from other jurisdictions like Washington, D.C., like different places in New Jersey, have shown, and also in O'Donnell in Harris County, Texas, have shown that putting measures in place to just remind people of their court date or bring them to court if they don't have transportation to court are just as effective at getting people to court as putting them in a cage. And actually, putting people in cages pretrial as a way to get them into court. Ken mentioned the fiscal responsibility side of this, how expensive these kinds of things can be. And what is really expensive here is putting people in jail. If you're holding somebody in jail for weeks, months, maybe even a year, that costs the county a lot more money than simply reminding the person of when their court date is or giving them a ride to court. Common sense shows us that that's much cheaper to just remind people of their court date than to hold them in jail for an extended period of time. Also, there are constitutional issues with holding people in jail for an extended period of time. But as for the effectiveness, there are several peer-reviewed studies showing that holding people in jail, especially for a week or more, actually has a criminogenic effect and increases the likelihood that the person will return to jail sometime in the future, mostly because when you hold somebody in a jail pretrial, you're destabilizing their entire life. They might lose their job because they're not showing up for work. They might lose their housing because they're not paying their rent because they're in a cage. They might lose their children because they're not taking care of their children because they're in a cage. So once they get out of that cage, even if they're found innocent, their whole life has fallen apart. And that creates a public safety issue. And that also creates a financial burden on their local government because all of their stabilizing forces in their lives, such as their housing and their family and their education, have been taken away. And that's actually a point that I agree with Ken on, that getting the family involved in a defendant's case is really helpful. And there are ways to do that without cash bail. There's something called participatory defense, where family members can help advocate for their loved one and say, we'll give them a ride to court. Here's where they work. This is the church that they're a part of. These are their children. Here are their connections to the community. We will make sure that they show up. So basically, the family in this participatory defense model is serving as the promise, to make sure that this person gets to court and that the case can be resolved. So that is actually a point I agree with Ken on, that getting the family involved is a very effective way of making sure that people come to court and that cases get resolved, all while preserving people's constitutional rights.
Well, let me just kind of respond to, we've had a couple of comments now that, these people are innocent until proven guilty and that should be taken as a consideration. They should not be held. The problem is that's actually contrary to the law. I mean, that is something that applies at trial. We have a presumption of innocence. You don't have to testify. But for release, it is solely what assurance are you giving to the court that you will return to respond to these criminal charges. And there are factors in statutes that the court has to consider. Innocence, presumption of innocence, is not one of those. And then the issue, I actually thought Kiah's response on it's cheaper to let them out than to hold them was a good argument until I spoke to the sheriff in the Schultz versus Alabama case. And he said, look, it's a lot more expensive in the long run if you're going to let people out with no accountability and watch crime go through the roof. And then you're having to try to get that under control, which is what they did for 4 or 5 years. And he said, that's the most expensive thing you can do. And I agree with that. I think that when you take away accountability, you have to expect crime will go up. I mean, you've got a city within the city generally. In Houston, you've got, a small group of criminals that are doing a lot of the crime. I mean, we talk about the people who have jobs, but we don't talk about our gangs. We don't talk about career criminals. We don't talk about the groups that make money by committing crimes, and organized crime. And so I think when we are talking about tying the hands of judges, maybe for a noble reason, but when we do it so that judges can't do anything about the bad sectors of society, well, then those parts of the community are suddenly going to grow because it's a green light to commit more crime. And I think a lot of what is the result, maybe not what they're arguing for, but the result of what Kiah is advocating for that's the result. We're tying the hands of judges so they can't address career criminals, organized crime, or gangs. And that's one of the reasons why we see crime going through the roof in our inner cities.
Kiah, I'm curious to hear how you address folks, because I'm sure that line of argument is something that you run into a lot. I mean, I'm a journalist. All I do all day is read media stories, and a very common archetype of a story right now is somebody's out on bail and they go commit some kind of violent crime, and that's on the homepage of the New York Post or whatever. So I know it happens, but I guess what I don't know for sure is how much should be tying that to something like abolishing cash bail, and how much we know about the relationship between those two things. So what do you say to people who intuitively just feel like, yeah, of course it makes sense if we, arrest somebody and let them right back out that they're going to go commit another crime?
Yeah, so I have a two-part answer to that question. The first part of my answer is that statistics from the federal government, the FBI, the Bureau of Justice Statistics, et cetera, all show that crime is not increasing. That's what the data from law enforcement itself is showing on a national level. However, people's perceptions of crime are increasing. So people believe that crime is increasing. That's definitely true. But when we look at the national statistics, crime is not increasing on a national level. And that is not only reflected in these national statistics, but also in peer-reviewed studies as well, which have been done across several different jurisdictions in the United States. And so that's the first part of my answer. And the second part of my answer is that I also very much care about community safety. And I do this work because I believe that we all deserve to be free from violence. We all deserve to be safe in our homes and in our neighborhoods and in our cities. And it is because I am so passionate about making sure that everyone is safe that I am against pretrial detention, and also for investments into things that we all know keep us safe, such as housing, healthcare, education, things that attack the root causes of violence, according to almost every study that's been done about what the causes of violence are and what perpetuates violence. The reality is, with tying this back to cash bail and pretrial detention, the reality is that pretrial detention destabilizes people's lives, like I said earlier, because even spending 1 to 2 days in a cage can cause you to lose your job, can cause you to miss payments on your bills and on your housing, and can cause you to lose your children, especially if you have small children that you don't return home to because you're being held in a cage due to an unaffordable money bail. So that kind of destabilization of countless people creates a public safety issue, because then people don't have the housing, healthcare, education, et cetera, to fall back on to be productive members of society. So releasing people pretrial and investing in the foundations of what prevents violent crime, again, such as housing, healthcare, education, livable wages, things that we all, I think, can agree are great for human beings, is a way to prevent violence. So I do just want to emphasize that crime is not increasing. People's perceptions of crime are increasing. And it's, as we're nearing an election year, it's important to point out that saying that there's so much violent crime, especially in inner cities, as Ken said, is a dog whistle to get people to vote for them. And it's also a dog whistle that has racial undertones, basically saying that Black people are dangerous and we need law and order to get them under control. And that kind of messaging is not new. It's been used since slavery. It's also used more recently in the 1990s with Bill Clinton and Hillary Clinton and their super predator rhetoric that led to mass incarceration that we see today. That's a dog whistle to get voters out. But the statistics and the data are clear that crime is not increasing. And the statistics and data are clear that the ways to make sure that people are safe and free from violence is to invest in housing, healthcare, education, livable wages, and other social and economic resources.
Kiah, really quick, I just want to follow up on that briefly. Obviously, or I'm assuming that the argument that you're making is that we're seeing crime come down while we're seeing bail reform or
Yes.
cash bail being, proliferated, basically. Because obviously, if cash bail is increasing and crime are going down, that would kind of undermine the argument you're making.
Yes, so I can point to some specific examples here because that's exactly right. To tie the crime rates to bail reform and what's really going on when we have bail reform, what's going on with the crime rates. So as I mentioned earlier, Civil Rights Corps had the O'Donnell case in Harris County. And then we also have a case called Urquidy in California. And in both of those cases, the DAs, DA Ogg in Kim Ogg in Harris County, and also a DA in Yolo County in California, self-published reports about crime rates increasing because of bail reform. But we've had experts, data science experts, review the data and actually find that crime has either remained stagnant or has decreased in the case of Harris County since bail reform has happened in the form of our lawsuits. And there's also been, in addition to having data science experts explain that crime is either remaining stagnant or going down after bail reform, there have been peer-reviewed studies done by several different institutions over several different years across several different jurisdictions that show that when there's bail reform, crime rates do not increase. That is the conclusion of peer-reviewed scientific research, as opposed to the kinds of reports that Kin references, which are reports that are made by district attorneys or by police officers, as opposed to by third-party data scientists who are analyzing the data in a scientific peer-reviewed way.
Ken, I want to get your reaction to two things. I know there's a lot there in the last couple of questions, or in that answer from Kiah. One is the argument that detaining someone while they're in pretrial and how destabilizing that is for their life. That resonates for me a lot. I mean, I think that makes a lot of sense. The idea that somebody's accused of a crime, they get put in jail and they miss a few days of work and they lose their job, and the snowball just kind of builds up from there. So I want to start there. I'm just curious how you think about that. And then we can talk about the discrepancy in the evidence that each of you guys are kind of citing and what kind of evidence you look to on the question of cash bail and crime. But I'm curious if that argument from Kiah lands with you at all, because when I hear that, I think it makes sense in the same way. The idea that, you let somebody free who's just been arrested for a crime, there's a good chance they might go commit another crime, makes sense to me. The idea that you arrest somebody who's accused of a crime and you destabilize their life by incarcerating them for a few days, that also makes sense. So how do you weigh that in your calculation?
Let me state it a different way. If you're a first-time offender, I would agree with you. But once you've got a criminal history, and what we're seeing more and more is extensive criminal history, if your bail is set in an amount you cannot afford, I don't believe you're in jail anymore because you're poor. You're in jail because of your criminal history. And I think that's a fundamental disagreement that I have with probably Kiah's position, because the reforms that they see are charge offense based. So no matter how many times you're charged with this offense, if it's on the simple release list, you have to be simple released. We've seen that in New York. And so we've had rollbacks because, criminals see that as a green light to commit that same crime over and over and over. When you get arrested 17 times, then I have a question about whether you should be released. I don't have a problem with you being held pretrial. I think the example that Kiah is highlighting is a first-time offender. I don't believe we have first-time offenders anymore. But let's go back to what she's saying about crime is not increasing. We saw that right before the last national election, right? 2 weeks before the election, people were coming out and, one side of the political spectrum was saying crime's not increasing. This is just jargon coming from the other side. And maybe it worked in the election. But, you really can't say that anymore. I mean, in the last month, the NAACP Oakland chapter came out blasting the local elected officials saying, we need a state of emergency on crime. Crime is rampant here in Oakland, And the DA came out essentially saying the same thing that Kiah is saying today. And the regional NAACP came out and said, you're wrong. The local NAACP chapter is correct, and that crime is increasing, and we need a state of emergency on crime. And so I don't think you can say that you can't say crime's not increasing anymore. When you have rampant shoplifting, where stores can't withstand $25,000 a day of shoplifting, and they're closing shop. I've never seen stores closing because of public safety issues, where you've got the Nancy Pelosi federal building in San Francisco sending an email to all the federal employees that work there, do not come to work from home. It is not safe to even walk from your car or to drive to work and walk into the building. I mean, you can't, I've never seen that before. And now you see San Francisco there was an article yesterday, in the last 6 months, 3 buildings have sold, one for 25% of its value, one for 40% of its value, one for 50% of its value. I mean, I wrote an article that's called The 4 Phases of the Spiral of Death for our largest cities. And those are all interconnected, and they all get traced back to crime, and those all get traced back to, we've decided to go down the road of simple release. And that is no accountability. We're releasing people with a green light to commit more crime. It creates chaos. You cannot overcome the chaos because you've created a system where you can't do anything to people who don't show up for court. And as a result, you end up having to dismiss crimes. The Yolo County DA, I did a podcast with him, and he said misdemeanor crimes in California have an 80% failure to appear rate. Statewide, you can't do anything to them if they don't show up for court. So you only get people to come to court that are doing it voluntarily. Other people see it as, hey, no problem. Nothing's going to happen to me. I can do it again. And that's what you're seeing. I mean, it's hard to have a discussion when we don't even agree crime's increasing and one side says the other side's a dog whistle. And here's the stat that says it's not a dog whistle. 50% of murders in the United States are being committed against young Black males. In our inner cities, it's even a higher number. And somehow the people who are murdering them are generally young Black males as well. And we have turned that whole debate, and we've somehow created that we have to cater to the murderer and ignore the victim. And that's where we are right now with the policies that are being pushed.
To briefly respond to a couple of things that Ken said. I'm sorry, Isaac, I know you're trying to keep us on track here, but just a quick response. First to the last comment you made about murder victims being disproportionately Black males. To be fair, victims of crime are disproportionately Black people. And again, as I said, I care about safety. I care about making sure that everybody is free from violence and is able to live safe, healthy, and productive lives. And as we know, the root causes of violence are often lack of resources, lack of economic opportunity, lack of education, lack of stable housing, lack of health care, including mental health care. That lack of resources is what causes a lot of violence to occur, most violence to occur, according to most studies about the root causes of violence. And so in an effort to make sure that people can remain safe and free, my argument is that we need to invest resources such as housing, healthcare, education, etc., into places where crime is affecting people. Because to be fair, to Ken's point, there are certain neighborhoods, although nationwide, statistically, crime is not going up. There are specific neighborhoods in the nation where crime is high, where violence is high, where people are not safe. And those neighborhoods are often under-resourced, as you could imagine. Most of the neighborhoods that have all of this violent crime are not neighborhoods that are upper middle class or rich. They're neighborhoods that have been significantly divested from in terms of housing, healthcare, education, and other crucial resources that are necessary to human thriving. So preventing violence has to do with investing those resources and has nothing to do, according to all of the statistics I've cited, with pretrial detention. And I do just want to, one last point that I want to make, or one last sentence I want to say, is that the national crime statistics that I cited are from the FBI, which I would not consider to be a leftist source at all. It is the Federal Bureau of Investigation saying itself that crime on a national level is not increasing. But in the specific neighborhoods where crime is increasing, we need to invest resources there.
I do want to make one point. I think we have an important concession here. And, my lawyer's coming out. I apologize. But, Kiah said that disproportionately black people have crime committed on them. The point that's missing is, by and large, the group that's committing the crime is from the same demographic. So we have a disproportionate amount of crime being committed on black people by black people. And the other point I would make is the point about the lack of resources. I mean, that sounds really good, and we should be spending more resources because we've already failed families. We've already had schools fail. We've had drugs running epidemic in our inner cities. But the problem is that is not an alternative to our criminal justice system. I don't want to take offense when someone says you're just playing a dog whistle. I don't want to, you're a dog whistle, or when somebody keeps saying cages over and over. But if you want to simplify the argument that's being made, it's like, you commit murder, here's your house, don't commit another murder. If they commit another one because we have no other plan, I guess we're just going to give them a summer home. I mean, that's not an alternative. That's not a way to fix this system. It's just, with all due respect, it's just rhetoric. There's no alternative.
Well, I think, there's obviously a middle ground between, providing resources for people and taking someone who's a murderer and saying, here's a house, don't worry about a murder. I think there's an ocean between those two things. So, I'm curious about finding that spot that's between those two ideas, or even, which side of that kind of framing we should be leaning into. I'm going to ask this question for both of you, but obviously in sort of a slightly different framing, or in reverse, I guess, really. Kiah, I want to start with you. Tell me about a situation where maybe you feel like pretrial detention is warranted, or does that situation exist? Ken is, pointing to what I imagine are often outlier examples. Maybe they're more common than I think, but maybe an example where someone's been arrested 17 times and released 17 times. That person comes back into a courtroom. They've gotten arrested for the same crime. Do you think that person should be held for pretrial detention? How do you think about those instances where, maybe it seems more obvious, like the community safety is really at risk by letting this person go?
I'm going to go back into my annoying law professor mode and reference procedural due process again. So one of the constitutional claims that we bring in our bail cases is procedural due process, which is basically the ability to have a lawyer and the ability to show evidence about why you should not be detained. And what that, in a nutshell, can be called is an individualized determination. And so the argument that places like Civil Rights Corps, where I work, are making is that, or the argument that we are making is that every single person who is arrested should be able to have an individualized determination to determine with evidence whether or not it's necessary that they should be detained pre-trial. And it might come out in that individualized determination that the evidence is looking pretty bad for this person. They look like they're going to be a threat to the community. They need to be detained. But the point is that there needs to be that kind of a hearing with evidence presented, with legal representation, et cetera, to make sure that we are only detaining the people who are flight risks or safety risks to their communities. And so to answer your question of when should a person be detained, the constitutional answer to that question is after an individualized determination through a constitutionally adequate hearing where a person has had the opportunity to present evidence and be represented by counsel and also confront the evidence of the other side. Also, just a quick point about the person who's been arrested for the same thing 17 times. Oftentimes, people are arrested and released 17 times because they can afford to pay their money bail. And so they're getting arrested, they pay their money bail, they get out, they commit a crime, they get arrested, they pay their money bail, they get out, they commit a crime. Or sometimes people get arrested multiple times after being convicted multiple times. So they get arrested, they get convicted, they serve a year in prison, they get out, they get arrested, they get convicted, they serve a year in prison, etc. And that, to me, is damning to our criminal legal system because it's showing that it's not working. If a person is able to pay money bail and get released 17 times, if a person is incarcerated and released 17 times, it's showing you that that incarceration is not reforming the person, is not preventing violence. And so that's, to me, an argument against the effectiveness of incarceration and against the safety value of money bail. And so to answer your question, I believe everyone should have an individualized determination of whether or not there's safety risk, where there's evidence, where there are lawyers, where we can make a determination as opposed to just slapping a money bail amount onto their probable cause affidavit and saying, if you can't pay that, you're going to jail.
Ken, so I want to put this question to you, I guess, like I said, in reverse, which is, I'm curious if there are situations where you feel like cash bail reform should exist, where you feel like somebody who comes in, is being accused of a crime should not be held for pretrial detention if they can't afford to post bail, should not be in prison if they can't afford to post bail. How do you think about that issue?
Well, I've been an attorney for over 30 years, and showing the wear from it, I guess. But, in the Texas legislature, where I spend a lot of time during the session on these types of issues, there's always some type of bail reform bill pending. And the ones that are good for the system, we support. SB 6 went through the legislature 2 sessions ago, and it had a lot of strengthening of the criminal justice system and underscoring or strengthening accountability. And I completely supported those measures, and it passed. I mean, the problem I have with what Kiah was just saying is the arguments that she's making have been rejected by the courts. I mean, both the Sanchez versus Alabama case and the Walker versus City of Calhoun case use bail schedules. And, the arguments they're making about those should be overturned and that you should have those things were rejected. The whole point about having an individualized hearing, think about it. We're going to require the DA to have an individualized hearing within 48 hours of arrest for every case. Sometimes they don't want to show their evidence that quickly. And we make it clear and convincing evidence standard so that it's not the judge's determination for setting bail anymore. It's a mini trial. Either the DA meets their burden of proof or they don't. I mean, historically, bail is an abuse of discretion standard, and it's the judge who's responsible for setting bail, not the DA. If we remove it from the judge and we make it all just a pure standard of evidence, which is very high, we make it almost impossible to hold anyone, which is exactly what the goal is, and public safety becomes more at risk. And we're spending almost all of our resources at the very beginning of the criminal case, and we don't have anything left to prosecute the criminal case. I mean, think of it. Like in our big cities, the criminal justice system is a conveyor belt. We average the same number of cases being added to the conveyor belt every day, every week, every month, every year. Anything that we do and everything that Kiah is proposing slows down that conveyor belt. And so to be able to get the same number of cases resolved in the same amount of time, we're going to have to double our courts. That's not going to happen. And so we have to find shortcuts. Well, right now in Harris County, which, we have this big disagreement. Last year, I looked at the misdemeanor courts, which is all O'Donnell is, and I looked for the month of August, their dispositions. 90% of the cases were dismissed. I mean, that's a collapse of the criminal justice system. We're keeping it from a total collapse by dismissing over 90% of the cases. Harris County is not a shining light. It's driving policy in Texas to the opposite direction. But we still have people going to other states saying, Harris County is the golden where you should shoot for. And we couldn't be more separated. We couldn't be more far apart on the differences. And where we have this problem is we can't even agree on the facts, what works and what doesn't work. We should be able to say, hey, this works. We should, anything that works makes the criminal justice system better. So what's good for the criminal justice system, shock of all shocks, is good for the bail industry. And so anything that's good for the criminal justice system, we're going to agree with. But these policies, and they are policies that they're trying to impose by court fiat, and they've now been rejected at every turn. They only have 2 cases pending at the Supreme Court right now, and they're on procedural issues. They're not even making the constitutional issues anymore at the Supreme Court. They're just doing procedural stuff. And so I guess it's just to keep their donors engaged that they're doing stuff, because they've raised over $30 million to raise these arguments that have all been rejected by the courts.
I want to focus just a little bit here, Kiah, because I want to get your response. And I know we're about at time and have to wrap up here in a minute. But how do you weigh that calculation? Because I do hear a real calculation in there that Ken's talking about, which is, say we decide that we're going to give every person who comes before the court this full understanding of the evidence at play and deciding whether we should be holding them for pretrial detention or not. We're going to overwhelm the system. And the result of that is going to be there's a much higher likelihood that people who may commit crime again are going to get released out on the street right away. How do you navigate that calculation in your mind when you hear Ken making that argument?
Yeah, so these questions are often posed to me as a trade-off between constitutional rights, public safety, and also judicial efficiency. And in my mind, there is no trade-off between the three when we acknowledge that many people can just be released pre-trial. People have a fundamental right to pretrial liberty. And so releasing people pretrial does not implicate any of their constitutional rights. It allows them to get back to work, get back to their families, get back to their housing, et cetera. So it doesn't impact any of these moral or ethical quandaries that I've been bringing up. And it also helps with judicial efficiency, because if most people are released pretrial, then we can focus on the individuals who we think might be a bit of a public safety risk and make sure the resources are focused there. And I want to be clear that releasing people pretrial is not dismissing their case. People who are pretrial have not been convicted of anything yet. They are before their trial. They're legally innocent. And so dismissing them pretrial, or not dismissing them pretrial, releasing them pretrial, is not dismissing their case. It's just allowing them to continue to meet their obligations in their lives until the date of their trial, where they may be found guilty or innocent. And so this public safety rhetoric that Ken continues to talk about is, just to be clear, statistically inaccurate. Crime rates are not increasing, not even in places where there have been bail reforms. This is according to the FBI and according to several peer-reviewed studies that I'm happy to send to you, Isaac, later if listeners want to look at them and read them themselves. And the real way to keep people safe and to keep our community safe is to make sure that people are housed, fed, educated, connected to their families, connected to their communities, have transportation to be able to get to court. So that way people's lives are stable and resourced, and they are less likely to commit crimes in the future.
All right.
In a lot of ways, we're repeating the same mistakes we made in the 60s. In the 60s, we felt safe. We started being more forgiving. We started releasing more people from jail. We saw crime increase. And we're now having the exact same thing happen. And the only other thing I would say is, Kiah keeps saying that fundamental right to release. So that's a constitutional right to release, which has been rejected by the courts, which means that local jurisdictions can decide what they want and without violating the Constitution. She keeps coming back to say they have no choice because it's a violation of the Constitution. Those arguments have been rejected. And I know we've heard several times, we have peer-reviewed studies. I'm just going to say, hogwash. That's just political rhetoric. And we shouldn't have political rhetoric. We should be able to agree on these simple things about whether crime is increasing, but we can't. It's just hogwash. I have a dog whistle, and she wants to give a free house to everybody that commits a crime. That's ridiculous, and we haven't had a good debate. Sorry.
Well, look, I think that there's some real solid ground and tension that exists here between your arguments. And, I'll certainly give both of you a chance to send over, any evidence that you have for your positions on the relationship between bail reform and crime that we can include in the episode description of our YouTube video and the podcast, because I'm sure people are going to want something that's, offers a little bit of clarity for them. And, I feel and see the contentiousness on this issue, but I think that, there are real pros and cons that people as citizens have to weigh. And you guys have articulated, your respective sides, and people are going to have to make up their minds on a lot of this stuff that, comes down to what makes the most sense to them when they hear your arguments up against each other. I don't want to frame anybody's perspective here as wholesale hogwash on either end, because I think fundamentally you both have an interest in preserving, the safety of the members of your community that you care deeply about, and you have different ideas about how to get there. But I appreciate you sharing them. We have to wrap up here. I'm going to give you both just really quickly 60 seconds. I'm curious. I know because of the interest we've gotten in this topic, people want to know what's kind of coming down the pike. So Ken, maybe I can start with you. What you're watching in this space over the next few months, the next few years, what cases, what issues you're keeping an eye on that you think people need to know about that might change, the legal or political framework of this issue?
Well, first, thank you for having me, and Kiah, thank you for having this discussion. I know I get frustrated at times. I don't mind having any argument, or discussion sometimes. But this is a passionate issue for both sides. What am I looking forward to in the coming months? There's two cases pending at the U.S. Supreme Court. One is Davis versus Dallas County, and the other one I just call the little case because I can't pronounce the last name because it's from Louisiana. Both of these cases are from the Civil Rights Court. They're on an issue of abstention. We call it younger abstention, and so the Fifth Circuit ruled that these types of cases cannot be filed in the Fifth Circuit anymore. And so I think these cases give the U.S. Supreme Court the opportunity to take that rule and apply it to the nation. And so we could be having this issue addressed on a very large basis. I think the briefs are due on the 23rd of this month and the 25th of the month, and then the court will make a decision on whether to grant the petition for cert. Probably the most, if we were going to make a bet, probably I'd say there's probably 60% chance they just deny cert. But if they grant cert, I don't think it's a good positive thing. I think with the current Supreme Court, it would take it and try to get rid of this litigation nationwide. So that's probably the number one thing on my radar going forward right now. And also, probably what's going on in LA, they just issued a study that says zero bail is an option, but when you read the study, it says the trade-off is increased crime. So there's a study right there that says the trade-off is increased crime, and we just need to put up with it, and a higher failure to appear rate. So there's a recognition right there. But we're saying, oh, it's an alternative. It is an alternative. You always have alternatives. They're just bad alternatives. But, the last thing I would say is the current trajectory is not sustainable. So we will have a course correction, because what's going on in our urban cities, you're seeing our mayors are the first ones that are come out and say, this is not sustainable. We need a state of emergency on crime. Because what's happening, where we're going, contrary to what Kiah's arguing, is not sustainable. And so we will have a change, and we will have a course correction. Thank you. But thank you very much for having me.
Yeah, thanks for coming on. Kiah, really quick before we go, what are you watching in the space? What areas are you keeping your eyes on in terms of, this issue nationally?
Yeah, so I'm keeping my eyes on the same cases that Ken mentioned. And I also, because I actually believe Ken and I do have common ground, which is that we both care about public safety. We both care about making sure that people live lives that are free from violence and that we can all feel safe in our communities and our neighborhoods and our cities. And so the things that I'm excited about and looking forward to are all of the creative ways that grassroots people on the ground, mostly Black people on the ground who are, as we discussed earlier, disproportionately victimized by crime, all of the creative ways that people are working together with their communities to figure out how can we make sure that our communities have the resources that we need so that we are not subjected to this violence and to this lack of safety anymore. And one of those ideas that community members have come up with and have been practicing for many years is participatory defense. As I mentioned earlier, I'm really excited to see different participatory defense hubs popping up around the nation with people from the communities saying, we want to make sure that our loved ones are safe and free, and we also want to make sure that their constitutional rights are protected. And so how can we do that? So all of these grassroots initiatives, from participatory defense, court watching, et cetera, many of the people who are in it are victims of crime who have decided to take it upon themselves to figure out how we can make the system better. That excites me. I'm really excited to see all of the alternatives that people are coming up with to cages and to pretrial detention.
All right, Ken Good, Kiah Duggins, thank you both so much for the time. I really appreciate it. And certainly an issue that I know a lot of people are keeping their eyes on. So I'll be in touch with both of you. Thanks again.